In this lecture, we shall discuss the enforcement or execution of judgments for the recovery of money by a writ of sequestration as well as by contempt proceedings. So the focus of the discussion is on two areas: enforcing judgments for the recovery of money by an order of committal or by a writ of sequestration. And remember, we are looking at these two different modes within the context of enforcing judgments for the recovery of money. The reason it is important to look at these two areas is because of Order 43, Rule 1 of the CI 47. If you will notice under Order 43, Rule 1, several modes have been listed to make room for the enforcement of judgments for the recovery of money. One of the modes is by a writ of fieri facias, and the other is garnishee proceedings. We have dealt with fieri facias, we've dealt with garnishee proceedings, we have also dealt with charging order, we have dealt with the appointment of a receiver in our previous lectures. The focus of this lecture is under Order 43, Rule 1E, which reads, in the case in which Rule 5 applies, an order of committal or a writ of sequestration. In other words, if you want to enforce judgments for the recovery of money, and it is a case in which Rule 5 applies, then we can enforce it by an order of committal or by a writ of sequestration. So if you want to enforce judgments and for the recovery of money, but it is a case in which Rule 5 applies, then you can go under an order of committal or you can go by a writ of sequestration. So we must find out what Rule 5 says. Then we can know what the foundation will be before we can come under this order of committal or a writ of sequestration according to the rules. Rule 5, Order 43, Rule 5 of the CI 47 is headed enforcement of judgment to do or abstain from doing an act. What it says is that where a person required by a judgment or order to do an act within a specified time in the judgment or order refuses or neglects to do it within that time, or within that time as extended or reduced by Order 80, Rule 4, or a person disobeys a judgment or order requiring the person to abstain from doing an act, the judgment or order may, subject to these rules, be enforced by one or more of the following means. It may be enforced by 1, a writ of sequestration against the property of that person with leave of the court. It can also be enforced by B, a writ of sequestration against the property of any director or officer of the body, where that person is a body corporate with leave of the court. And it may also be enforced by an order of committal against that person, or where that person is a body corporate against any director or other officer. Now, let us take a critical look at Order 43, Rule 5. It says that where a person is required by a judgment or order to do an act within a specified time. So, for example, the court orders you pay the plaintiff an amount of 500,000 cedis within 6 weeks of this order. This one, it is an order that has been given with specific timelines. So if on the 7th week you haven't paid the money, it means you have disobeyed the court. You are in contempt of court. And the consequence of contempt, you can be put into prison. You can be fined. Because it's a quasi-criminal matter. So you see, Order 43 Rule 5 contemplates situations in which you have been given a specific timeline to do or abstain from doing something. Once you don't pay the money in the 6th week, it means that you have disobeyed the court. So we can bring contempt proceedings against you according to what the rules are saying. Take a critical look at Order 43 Rule 5 once again. It reads as follows. Where a person required by a judgment or order to do an act within a specified time in the judgment or order refuses or neglects to do it within that time, or within that time as extended or reduced under 18 Rule 4, or a person disobeys a judgment or order requiring the person to abstain from doing an act, then what does it say? A. We shall execute it by a writ of sequestration, or C. an order of committal. So before you can go for an order of committal, it means that there must have been a judgment that the judgment debtor was ordered to do something within a specified time, or he was ordered to do or abstain from doing something, but he has disobeyed. So for disobeying the courts, we can trigger sequestration or we can trigger committal proceedings. That is what it means. So now let's go back to Order 43 Rule 1E again. It says, a judgment or order for the payment of money may be enforced by one or more of the following means. E. In a case in which Rule 5 applies, an order of committal or a writ of sequestration. In a case in which Rule 5 applies. Now you know what Rule 5 says. Rule 5 deals with when you have been ordered to do something within a specified time, or you have been specifically ordered to do or abstain from doing something, and you disobey. It means you have disrespected the court. So the rule says that we can enforce that order that compelled you, directed you to do something. We can enforce it by a writ of sequestration or by an order of committal. So the reason we'll bring the sequestration or the committal is because you have disobeyed the order of the court. That's why we can bring it. So if you know the case of Kanga is spelled Kangah versus Chere, Kyereh, reported in 1979. Ghana Law Report at page 458. The court noted as follows: that to obtain a committal order for contempt, the applicant must strictly prove beyond all reasonable doubt that the respondents had willfully disobeyed and violated the court's order. End of quote. You see, Kanga and Chere is saying that before we bring contempt proceedings against you, you must have willfully disobeyed the orders of the court. So when the court says, pay the money within 7 weeks, and by the 10th week you haven't paid, it means you have disobeyed the order of the court. So we should be able to bring contempt proceedings against you. That is if you go according to Order 43, Rule 1 and the Rule 5. But there's a real question we must answer. Imagine you have judgment against me, and the court orders me to pay you 10 million Ghana cedis within 6 weeks, and I can't pay the money. Are you saying I should go to prison for not paying money? Should contempt really be the procedure and your option? If the court orders me to pay money and I can't pay, should I be going to prison for it? You can imagine the number of people who go to prison for contempt. So there's a real question we must interrogate: whether contempt is what we should resort to. What the rule is saying, is it not in any way going to affect people's fundamental liberties? Because you're going to infringe upon my freedom to move about, keep me in Isawam for five months, because I have not been able to pay money and I rose out of a civil transaction. Think about it. Is contempt really the way to go? If we juxtapose these rules against the constitutional provision, will it really hold that a debt arising out of a civil transaction, you ordered me to pay within 6 weeks, I couldn't pay, so I should go to prison for it? This question came up in the case of Republic versus High Court, Fast Track Division, Accra, as per the PPE Limited. Republic versus High Court, Fast Track Division, Accra, as per the PPE Limited. Reported in 2007-2008. One Supreme Court of Ghana Law Reports at page 188. The essential facts are that the judgment or debtor in this case did not comply with the orders of the court to pay the judgment debt within 6 weeks. So the court ordered, pay the debt within 6 weeks. But the judgment order failed to comply with this. Consequently, the judgment creditor commenced sequestration and committal proceedings against that particular person. The judgment creditor commenced sequestration and committal proceedings against that judgment debtor. And what did the court hold? The Supreme Court delivered itself as follows, and I quote, "The issue of civil liberty raised is whether in this day and age imprisonment should be an option available for failure to pay a debt. I am very much doubt whether this is the restriction on personal liberty that is justifiable in a civilized democratic country. Accordingly, only very clear and compelling statutory language would persuade me to reach the conclusion that a person should go to jail for the inability of this company to pay a debt, which is the essence of the facts of this case." Again, the issue of civil liberty raised is whether in this day and age imprisonment should be an option available for a failure to pay a debt. I very much doubt whether this is a restriction on personal liberty that is justifiable in a civilized democratic country. I very much doubt whether this is a restriction on personal liberty that is justifiable in a civilized democratic country. I'm referring to the case of Republic versus High Courts, Fast Track Division, Accra, ex parte PPE Limited. The judge is saying that I very much doubt whether this is a restriction on personal liberty that is justifiable in a civilized democratic society. So what we get from this case is that contempt application cannot be resorted to enforce the payment of judgment against the judgment debtor. Why should people go to prison for failing to pay a debt? So many people go to prison, and that is the case. So, on the authority of Republic versus High Court, Fast Track Division, Accra, ex parte PPE Limited, reported in 2007-2008, one Supreme Court of Ghana law report, you can't put a person behind bars for failing to pay a judgment debt. So this case has made significant inroads to this Order 43 Rule 1E of CI 47, because the Order 43 Rule 1E of CI 47 was supposed to allow people to be imprisoned when they fail to pay debt within a specified time. But remember the case of Republic vs. High Courts, Fast Track Division, Accra, ex parte PPE Limited, that in this day and age, that will not be a restriction that will be justified in a civilized democracy. So, on the authority of this case, we can make a strong argument that contempt proceedings cannot be brought against a person who has merely failed to pay a judgment debt to a judgment creditor. That brings us to the end of our discussion on committal. So, in as much as Order 43 Rule 1E provides committal as a means of enforcing judgments for the payment of money, remember that the Supreme Court has mentioned that in this day and age, it doubts whether that is a restriction on personal liberty that can be justifiable in a civilized democratic society. So we frown on contempt applications to compel people to pay a judgment debt. So as far as I'm concerned, you are supposed to resort to other convenience modes of enforcing your judgments, but not committal, if it's about payment of debt. The next we shall look at is sequestration. And to explain sequestration, I shall make reference to Order 43 Rule 1(3) of the CI 47. It reads as follows: a writ of sequestration shall be directed to 2 or more commissioners to be appointed by the courts for that purpose, who shall be commanded and empowered to enter any immovable property of the person against whom the writ is issued, and to collect, take, and obtain not only rent and profits of the property, but also all the person's goods and movable property, and detain and keep them under sequestration in their hands until the person is cleared of the contempt or the court makes an order to the contrary. To put this in a better context, remember what we saw under the Order 43, Rule 5, which is the foundation to even bring sequestration. They say that there must be an order directing you to do something that you have failed to do. So sequestration is like supposed to put you in a very uncomfortable position so that you comply with the orders of the court. Remember, under the 43 Rule 5, we can only go for sequestration when there's an order directing you to do something that you fail to do. So to more like punish you, the rule contemplates that we shall appoint 2 or more commissioners. They shall enter any immovable property that belongs to the judgment debtor, collect all the rents, collect the profits. They are holding it. They are making it very uncomfortable. They also detain the goods, and they will keep them in their possession until you, the debtor, you are cleared of contempt of court, or the court makes an order to the contrary. So before we can bring sequestration, first of all, according to Order 43 Rule 5, there must be something that you are ordered to do that you fail to do. It means that you have disobeyed the court, so you are in contempt of court. So to compel you to respect the court, the rule says that a sequestration shall be directed to 2 or more commissioners to be appointed by the court for that purpose, who shall be commanded and empowered to enter any immovable property of the person against whom the writ is issued, and to collect, take and obtain not only the rents and profits of the immovable property, but also all the person's goods and movable property, and detain and keep them under sequestration. Now focus. Detain and keep them under sequestration in their hands until the person is cleared of the contempt or the court makes an order to the contrary. Means that the whole reason why we are doing this is to compel you to respect the court. That is when we can go for sequestration, making you very, very uncomfortable, like more like punishing you for you to respect the court's decision. I shall wrap up this lecture by first of all indicating that the basis of sequestration is that there must have been an order for you to do something that you fail to do, and it relates to money. Now, in light of this decision in Republic versus High Court, Accra, as per the PP Limited, I want you to interrogate and find out whether we can also bring sequestration in terms of people that have been ordered to pay money. Because as per the PP Limited says that we can't resort to contempt, and that in this day and age, we can't resort to committal proceedings if it's about payments of money. Now, remember that the foundation before you can even make sequestration is that the person must have first disobeyed the court, and he must have been in contempt, disobeyed the court. That is why under sequestration, you go for it, and the goods will be held in sequestration until the person is cleared of the contempt of court. So in this time, as per the PP Limited is saying that you can't come for contempt if it's about payment of money. Find out whether sequestration, you can still come for it in light of the decision as per the PP Limited. Because remember, the foundation of sequestration is under 43 Rule 5. And it says that there must be an order directing you to abstain from doing something or do something within a specified time, and you have disobeyed it. That is why we shall bring sequestration. And the essence of sequestration is that we shall continue to hold the goods under sequestration until you are cleared of the contempt of court. Now you have been told in ex parte PP Limited that we don't have contempt when it's about payment of money to your judgment creditor. So interrogate and find out whether sequestration too, we can rely on it if it's for the purpose of enforcing somebody to pay a judgment debt. I shall finally wrap up with the words of a learned author in the leading book in civil procedure in Ghana, very recent. is a book titled Civil Litigation in the High Court of Ghana, authored by the Robert Smith Law Group, Bobby Banson, lead author. Published in 2022 at page 218. This is what the learned author says in relation to sequestration. This mode of execution is rarely resorted to by lawyers for reasons not at all far-fetched. In England, where it originated, it has been abolished, and most judgment creditors find more alternative, convenient modes of execution. In England, where it originated, it has been abolished, and most judgment creditors find more alternative, convenient modes of execution. So, my question to you remains that if it had been abolished in England, and even on the authority of ex parte PP Limited, we are found on contempt proceedings to enforce judgment for the recovery of money. My question to you remains that find out whether sequestration can still be resorted to enforce judgments for the payment of money. This is where we shall draw the curtains in this particular lecture. Thank you.